Hello, everyone. Welcome to Court with Krissy. Judge Rossi gives all the legal advice today in court. The dilemma: this inmate's $466,000 MDOC judgment has gone missing. He trusted it with a chick. Will you have any sympathy for this man that's been convicted of second-degree murder? Now, if you excuse me, I need to go look at my spring clothing line samples and call the cosmetic lab about my lip kits. I hope you like it. Court with Krissy is now in session.
And this matter comes before the court this afternoon on Mr. Robinson's various motions, asking essentially the court to set aside or vacate the consent judgment agreed to on the record during our last hearing. Mr. Robinson, would you state and spell your full name for the record, please?
Javonte, Javonte Robinson, Robinson.
All right. And Mr. Robinson, I did review what you filed, indicating to me that you think that the defendant here, Jemiah Smith, was untruthful in responses during the last hearing, and thus I should vacate the settlement and allow this case to go forward. Anything additional I should know?
No, that's correct.
I did note in one of your filings, you made a reference to J.G. Wentworth as, potential third party or someone else.
Just an example. Yeah, that was just like an example.
I see.
Like
So
yeah.
I mean, J.G. Wentworth, in my experience, is a company that buys like judgments and settlements and things like that. And gives a cash payment or time payments in return for those sometimes, but there's not some money that's coming from J.G. Wentworth that we didn't talk about last time, in other words.
I'm confused about the last part. You said is
well, there's not for example, you don't have a life insurance payment or a settlement from a lawsuit that J.G. Wentworth owes you money for and gets them involved in this action.
Okay. Even though that this actually the money came from a settlement?
Well, did it come from I mean, is that where that $400,000 originally came from?
It came from a settlement.
Okay, was it via J.G. Wentworth?
No, it was a settlement, MDOC, juvenile prisoner.
Okay, all right. And that was paid to you?
Yeah.
What year was it paid approximately?
It was 4 or 5 payments. The first one was July 2020 all the way until the last one was November 2023.
Okay, and you didn't sell the right to those payments to J.G. Wentworth or anything like that?
No.
Okay, all right. And are they done and over now, or are there more payments coming?
No, it's done and over.
Okay, all right. And the total of those payments made in the 3-year period approximately was $400,000.
Yeah, it was roughly $466,000.
Okay. And what year, when were you convicted and sent to prison this time around?
2021.
I see. So those payments were in effect, they were still coming in at that time.
Yeah. Well, I was in prison when it was coming in.
Got it. Okay. Well, and that whole issue isn't before the court, and whether or not, my experience is, what the Department of Corrections does, especially if this was a payment that would have been coming from Department of Corrections. Is that who the payment was made by, or was it MDHHS or something else?
No, it was made by the MDOC in the settlement, a class act settlement, and then my attorney is the one who dispersed the money.
Got it. Who represented you in that?
Deborah LaBelle out of Ann Arbor, Michigan.
Okay. All right. Well, and You know, my experience is if you have money coming like that, a lot of times, you know, what the state does is they try to seize it and place it in some sort of constructive trust or something like that, so that, you know, then they use it to pay for your cost of incarceration, and they got a way they calculate
Yeah,
that.
they for the guys that was in prison,
Yep.
they was allowing them the option of having it in their prisoner trust account, or if you was in prison, you could a bank account through that Deborah LaBelle and the other attorneys that represented had set up. But I was actually in the county jail, so they couldn't put it in my prisoner account because I was in the county jail. They couldn't set me up a bank account because I was in the jail and not the prison.
Got it. Got it. You
So
were kind of in a
that was the
limbo.
dilemma.
I see. And what you did is you had the defendant here, Jemiah Smith, open an account and had the money deposited into there.
Correct.
And that was the route of that the money went. Okay.
Correct.
Well, yeah, and what did she lie about? You said she lied about her current ability to pay. Your thinking is, well, you know, as of at least November of 2023, there must have been some money going into that account. There should still be some money there.
She actually closed that account, transferred everything from that account to her solo account, and then closed that account. So that account is no longer open. So
yeah, the money, in other words, it got dispersed for whatever reason by her, you know, because she had control of it. Now, the one account that it went into the first time, that was an account that, I mean, because you were in jail, she was the only one that was on the account, right?
No, my name was on it. My name was on it. That was the only way that the
Attorney
Deborah
would do it.
LaBelle's office was send it if my name was on it. So my name was on the account. It was her original account, and then I became, I believe, added on there. But I was on there for sure because when
and as far as you know, that was a joint bank account. In other words, you both had total access to all the money that was in there.
Yes, sir.
Yeah. Okay. All right. Well, I think I understand, you know, kind of what the parameters were, where the money came from here. You know, and what gives you the idea she's got some of this money that she's got access to right now, and that it's not all been dispersed out or spent, you know, even if she wrongfully spent it on her own personal stuff? What gives you the idea she has more of it to give to you than $100 a month?
She still, I know she spent a large portion, or I don't know how much exactly. She won't tell me what's left or how much she spent, but she still does like little fashion shows and things of that nature. Like she has a clothing line and little makeup line that she still a few times a year she does fashion shows for those.
And you're thinking that what she's doing is taking the money from you. And I mean, does it cost her money to put on the fashion show, or does she just participate in someone else's show?
No, it's her actual show.
Okay, so she spends some money.
She pays the video person, the models, the pay for the venue. It's all her.
Got it. How do you know about that stuff?
Well, I have not recently, but she was sending pictures of the stuff like to my JPay account. I get pictures of new clothing or new fashion show or makeup, whatever it was. She'll send me the pictures, and then just keeping in contact with her social media posts, seeing that she's in mutual friends, and she still posts like immediately. June 21st of this year, immediately after we left the summary judgment, she actually wrote a prisoner here that we both know and said, your friend won 200,000. I hate him so much.
Okay. Well, yeah, I mean, and that reflected the fact that she settled it and, probably was, at least a little bit unhappy because I was informed her, that judgment, once it, enters here is on the record for, 10 years, and then you can renew it for up to another, at least 10 years. I mean, so, she's looking at 20 years. How long is your sentence? How long are you in for, Mr. Ramos?
20 years.
20. Okay. Well, and you're 20.
A little longer, but roughly 20 years.
I got it. So, I mean, it's conceivable that you could get the judgment, renew the judgment, come out, and you'd still have the judgment enforceable against her. Um, just thinking through the possibilities here. And is your statement to me today that you think she's using a secret stash of that money that she keeps somewhere to put on these fashion shows, and that proves she's got more money, or that she's earning more money that comes into her name because she's still selling her clothes and cosmetics and stuff?
That is the main thing, and because she refuses to say, how much she has left, or what did she spend on, and what did she spend it on, or whatever the case may be. She refused to answer any questions
never
about
really
that.
given an accounting of what happened to all that money.
Right, and even before this, I was used to ask her, like, what's going on. She just always beat around the bush, wouldn't answer the questions about it.
Yeah. Okay.
So I'm really in the dark.
Yeah, as usually, when there's money taken, whether it's from a corporation or individual, that's usually, the big question is, well, what happened to that money? And unfortunately, my experience in handling cases on all sides of the coin here, I've represented people that lost money and people that took the money, is usually, well, I spent it all except for, here's a few dollars. I remember I had one guy who embezzled like $8 million from a supermarket, and he had like $50,000 worth of coins that he turned over to the, he had like a gold coin collection or something that he turned them over to him. But they were like, what happened to the rest of the, 7,900,000? And he couldn't really account. People, uh, people who steal money usually aren't good at accounting for that money. So, it doesn't strike me as impossible that it was all spent probably on stuff that you wouldn't approve of, but nonetheless all spent, and that she doesn't have a secret. If she had a stash, it would seem like she'd be hiring a lawyer and trying to get your lawsuit dismissed, because, she's got an upper hand with you in prison. So, I just didn't get the conviction that she had. And plus, she didn't look like she had that much money. She was taking some time off of a regular job that she's working. I mean, usually people that have a big stash of money, they don't feel the need to go out and, work an hourly job. They're living off the fat of the land or whatever with that money. So, I mean, I just looked at all those circumstances, and I didn't think necessarily that you were getting taken for a ride in the deal. I'm just trying to get a basis for the reason that you do think that. Now, on a secondary question I have for you, Mr. Robinson, is, say I set this aside, say everything went great for you. You won the case at a trial, and I'm not saying this would be the case at all, because, you frankly got about 100 obstacles to being able to try this case. And the fact, what were you convicted of that got you in prison for 20 years?
Second-degree murder.
Yeah. Well, that may or may not come out at the trial, but I guess it doesn't really matter. They're going to figure out that you're in prison, and they're not going to have a lot of sympathy for you. And, the issue is going to be then, will a jury, but if the jury gave you all that money, what's to say the Department of Corrections then isn't just going to turn right around and slap a lien on you and say, you know what, nice job at that trial. You got $400,000, and we'll take 390,000 of it, and you can get the rest of it, farmed out at you at $100 a month into your JPay account from that $10,000.
The money was because it was the settlement against them. They couldn't touch it. Like, even if I was in prison during the time of the disbursement of the money, they would have put it in my prison account. They wouldn't have been able to touch it. So if I was in prison, I could have got the whole 400,000 plus put in my prison account, and they couldn't touch the penny for it because it was a settlement against the Department of Correction.
I see. So even the folks, at least as far as that got that, because that's not the case at all in the other. Now, I haven't had a case like yours where the money came from Department of Corrections, these are other people, for example, your rich uncle dies and leaves you $100,000. Well, if you're in prison, the usual reaction of the Department of Corrections and the Attorney General's office is to say, hey, that money belongs to us to pay for your stay at the
Yeah, that's
Department of
definitely
Corrections.
true.
Yeah,
That is true.
that
But in
wouldn't
this
happen
case,
here.
it was stipulated that it was not to be touched.
Not to be snarfed down by the Department of Corrections because
Unless you owe like fines, then they was taking the money out for the fines and everything else was like you didn't have to pay no room in the board or nothing like that.
Yeah, okay. In other words, Department of Corrections agreed special deal to protect that money. Now, here's the thing, and I'm just thinking out loud here. That scenario happens, you win. Well, you're not, that money's no longer, we're gonna, and you're correct. You could, and some of the stuff you sent to me, like those interrogatories, requests for financial disclosure, and like a freeze on property. Those are things that typically happen after a judgment issues. In other words, if I issued a judgment after a trial and it said she owes you $400,000, then you have some remedies. You could freeze, you could put a lien on her house, you could freeze property that you could put a lien on her car. Any real property that she owns, you could take some action to get, some satisfaction of the money that's owed to you out of that judgment. Now, there's no circumstance that I can think of here where that would happen before judgment. You can't usually exercise those rights, before the judgment's rendered. So, in any event, that stuff's not available to you right now. I'm also thinking out loud here as you come down the road, you do that, you get a lien on her house, someday she sells her house, say she owned a $200,000 house outright because she spent the money on that or a condo or something, and then she sells it. Well, then all of a sudden that money's, in effect, what she's done is she's laundered that money that came from the Department of Corrections. It doesn't have that Department of Corrections protection attached to it anymore. It would just come as a judgment payment to you. Now, you could go back and make an equitable argument that is something that's not, covered by normal legal channels, and you could say, hey, this started out as Department of Corrections money, and everything else is water under the bridge. You should still treat it like that, and Department of Corrections might do that, but they also might not do that. Attorney General might say, hey, we think you ought to pay us the amount due. So can you remind me, Mr. Rossi, when I entered the judgment on the record, did I enter a provision where she's to make additional financial disclosures down the road to inform the court and you whether or not her financial position changes, like on an annual basis or anything?
You did say that.
Okay.
If her financial situation changes, then to notify you.
Good. Okay. Well, and that though it's and I'm going to refer to that as kind of cold comfort, but nonetheless, in effect, then that'll keep your if she is hiding some of that money, it keeps your cause of action against her alive, because every year she hides it and doesn't reveal it to the court and to you through some sort of disclosure statement, then you potentially have another cause of action against her because she's lied to the court and she's lied to you. So it gives you some more avenues to collect that, in the event that you get out, or in the event that you find an attorney to kind of explore these different avenues for you. But right now, as I see it, Michigan law is pretty clear. Once we put a settlement on the record, it's a done deal. It's like a sentence. It takes an extraordinary event to set it aside. I can't set yours aside. You've told me some more information today, and that is helpful to me. I don't know that it changes the complexion of the case. It helps me understand what's going on here a little bit better, but nonetheless, the bottom line is you trusted someone to hold on $400,000 that was coming your way, and she, at least to your mind, anyways, misspent or misallocated the lion's share of that money. I understand some of it went where you wanted it to, but that was a small amount. However, the fact that she's writing and she's saying, hey, I'm not happy, and that I got stuck with a 200,000 judgment, because that does have some value to you. Your day-to-day value now is pretty low. It's only $100 a month into JPay. However, once you get out, or should you be able to retain an attorney and having some money in JPay to pay for postage and stuff like that, will help you at least make those inquiries out there in the legal community, and people in the legal community know that a judgment has value, and they also have the resources to do what you probably can't do for where you're sitting inside and do a more, if it were a commercial lender, if it was a business or something, well, a business will go on Lexis or Nexus and they'll do an asset search and see what that person's got in their name. So at least if if she did have a piece of property somewhere or title to a Bentley or something like that, you would see it, through doing that search. But obviously, you're not going to be able to do that from where you sit, not legally, anyways. So you would need an attorney's help, and I can't do it. As a court, I can. I've already probably given you more legal advice than I should. As a judge, all I can do is apply the law, to the facts that are in front of me. So what I'm saying to you is just recognize that $200,000 judgment has value. She's making these minimal payments, but I think when I ordered that I ordered it, it's going to have interest accruing. So really, even when you get out, if you renew that judgment, and you should pay attention to the date on it when I sign it and send it to you, because you'll need to renew it in 10 years to have it still potentially there. Well, it still will be there unless she dies when you get out. And then you'll have the protection of that judgment. And frankly, it'll probably, because she's not even paid enough to cover the interest on it, it'll have some value to you when you get out. And in the meantime, you can reach out to attorneys and say, hey, is there any, recognizing obviously anyone would rather have $200,000 in right now than you would rather a judgment for 20 years. Nonetheless, attorneys can explore that and tell you, in their opinion, whether it's worthwhile or not, and you'll have some resources to pursue that. And so I can't, we have a kind of a saying in the legal community there that when both sides are upset with the settlement, it was probably a pretty good settlement, meaning that both sides, in your case, you cut the amount in half, and in her case, she's admitting to a judgment that's going to be on her record for 20 years. So, you both gave something substantial in the case, and further, she's going to make these $100 a month payments to you. I know you'd like more, and I would too, frankly, sitting in your shoes. But $100 a month is better than nothing a month. And, as long as it's just a lawsuit out there, then it's worth nothing a month. So I think it was a good settlement. I'm going to leave it on the record. I will reduce that to a judgment in writing so that you have a copy of it with a date on it, so you know when you need to renew it. She'll have one as well. I'll review those disclosure provisions in there to see what I ordered. And, we'll hold her to that too. And I can't remember if I ordered her to, update me annually or exactly how that was going to happen. But, there is some protection in there in case she got a windfall, because you never know. Sometimes, she would get an inheritance, or maybe her business would take off and all of a sudden, she's going to be the next Cardi B or something out there, and fortune coming your way.
So with the judge, okay, you said if you keeping the judgment, right?
Yep.
So then would I be able to then do the interrogatory questions and the seizure because it's a judgment?
It is a judgment, but it's a judgment with periodic payments, and the only way that and the periodic payments are made at the rate of $100 a month. So the only way you can go above and beyond that, well, there are two routes. If she doesn't pay, then that triggers and the whole judgment amount goes into effect against her, at that time, if she misses a monthly payment. Or, so that gives you some insurance that, hey, I got at least $100 a month coming in. So, I can buy stamps and postage and stuff like that. And then second, would be if, you got an attorney to take the case, that attorney did that deep dive into her assets and found that she was non-disclosing, then you could have him bring a motion to accelerate judgment, they call it, or impose the whole judgment. And then we would impose that whole amount. And then you could, but you'd have to have proof of that. I mean, it would have to be, yep, that's definitely there. It's in her name. She has a right to defend herself and hire an attorney and stuff too. In the event that something like that happens, to prove that no, you got it wrong, Mr. Attorney. That's not the right person, or, you got the wrong name when you did your asset search or whatever. And, she has rights to defend herself. So it doesn't happen like in the snap of a fingers. And in that event, if I order the judgment, what we call accelerated, then it's all due and owing again. And then you have all those remedies of interrogatories on her financial situation, freezing assets, etc. But not if she keeps making her $100 a month payments and she doesn't lie in her disclosure statements, then you don't have any of those remedies available until one of those two things happens.
Okay.
Very
Understand.
good. All right. Thank you, Mr. Robinson, for explaining everything to me this afternoon. And I will get a judgment entered into you as quickly as possible so that you got the dates and stuff so that you know. And of course, you got to keep a copy of that in a safe place. And, if you can do a scan of it or a photocopy with resources you got there, so you got a backup copy or someone holds one for you, anything you can do like that, it's an important, and of course, we will have the document under the case file here at the court as well.
I hope you like it.